it's not just elder care law. There's a lot of family dynamics that come into elder care. And this practice can help with a lot of different things. I know the owner. He is a very nice man. I've had the pleasure of knowing him for a very long time. And it is an honor today to have Carol come and speak.
Thank you very much for having me. I just want to say thank you for the lunch and for everyone who has been here to host and to participate and for you to stick around. So I've been practicing law here in Oklahoma for about 17 years. I've worked with John Alberts several times during that period of time for several years. And so we do a little bit of family law, we do a little bit of estate planning. Those things overlap a lot. So when we talk about estate planning, so this is participatory, so I need you guys to participate. Tell me who has an estate.
All of us.
Everybody does, exactly. Every single person, whether it's just a clothes on your back, you have an estate. And so when's the best time to do estate planning?
Now.
Now, yesterday. And that's why we call it planning, right? It's something that we're planning for. So a lot of people put it off because they don't want to plan for death. Well, that's not what estate planning is. Estate planning is we're going to look at you today, see what's going on in your life today, and make sure that we can make sure your health, safety, and welfare is being provided for from now until you pass, and then we're going to make sure that the distributions of your estate go to whom and how you want those to go. So that's planning. And there's a lot of different aspects that go into estate planning or into family law. So when we talk about family law, pick up that piece. What do we do in a family law practice? Sometimes it's divorce. Sometimes it's child custody. Sometimes it's modifications of custody, visitation, child support. Sometimes it's guardianships. Guardianships of minor children, but also guardianships of adults. So when we talk about estate planning, what are we talking about? Are we talking about every single person in here needs a trust? Is anybody getting those flyers? Come to my fancy luncheon. Let's talk about a trust. Okay? I started getting those in the mail. Okay, so they must know our birthdays. Estate planning is not one size fits all. Okay, there is no one size fits all. The best thing I can tell you is to be educated. Know what kinds of questions to ask. Not every single person needs a trust. It may not be the right vehicle for you. And then what kind of trust? If you even got a trust, there are lots of different types. Okay, there are two types that for a lot of different objectives. You may have a revocable trust, you may have an irrevocable trust, but what's the purpose of that trust? Is it somebody has special needs and we don't want to disrupt what kind of benefits they're getting? Or is it we have a blended family and we have, we're on our second or third spouses and there's an aspect that has to be divided between the spouse and the children. There are lots of different reasons. We may have a reason to try to lower our tax liability. So the purpose behind the trust will also help us guide to what kind of trust or planning that we need to do. So if you were to call my office, I would want to just talk to you. We're going to have a conversation for about an hour. And in that conversation, I'm going to get real super nosy about your life. I'm going to ask you about your spouse if you have one. I'm going to ask you about your children. I'm going to ask you about the relationship you have with your children. I'm going to ask you what kind of bank account you have. What kind of CDs do you have? Do you have other titled property? Are all your assets in Oklahoma? I'm going to ask you about life insurance. I'm going to ask you what you want. What do you want to happen whenever you pass? What do you want to happen before you pass? What if you are incapacitated and you can't make your own decisions about your health care or about your finances? Who do you trust to make those decisions for you? Who's that doctor going to go to ask those questions? And we want to do it now while you have the ability to know. The doctors want you to do that while you have the ability to know, because those are your decisions to make. And if you die and you have nothing in place, then our legislature has been so gracious to create a great big statute that says what they're going to do with your property And that's what a judge has to apply when you don't have a will or a trust, or we haven't set up provisions to ensure your property gets to who you want to have it. Okay? So for example, let me give you an example. Been married 30 years. I'm on my second spouse. I have 4 other children from my previous marriage. I die. I've got title to property in Oklahoma, real estate. It's just in my name. How does that property get divided? It does have to go through probate, but the statute says 1/2 goes to my spouse and 1/2 gets divided through my children. Maybe I thought my spouse was going to get that property and was going to be able to continue to live off of that property throughout their lifetime, but I didn't take the steps to ensure that was correct. So there are lots of nuances in the law and ways that we can go about crafting a plan that's going to help meet the needs that you have, both while you're living, aging, and then after death. So to know which is going to be the right avenue just takes a lot of conversation to get to know you and to get to know your family, to get to understand what goals that you have. Maybe you say, well, I don't want to trust, they're complicated and they're expensive. Well, they can be, and they can be really simple too, but also probate is a very expensive process as well. If you want to add some specialty provisions, for example, so I have a grandchild and I would like my grandchild to go to OU because we're in Oklahoma, and if you're not an OU fan, you're not truly from Oklahoma. Right?
Yes.
Yes. I have no preference on football, but I know there's a lot of people in this state who do, right? So maybe I want my grandchild to only go to OU, and I'm willing to pay for it. Then I'm going to pay for their classes for a 4-year degree, and I'm going to make sure that I give them $1,000 each month to help with their expenses. Am I going to be able to do that through a will? No. So when we put special limitations on distributions, and we want to build in provisions that say we want this to happen at this time, but only if this happens, we need to do those things through a trust. But we don't know that until we start asking questions. So when I tell people, what do you think a will does? What's the purpose of having a will?
It's your will. It's what you want to happen.
It is your will, and she hit on something really, really positive there and pretty impactful. It's what I want to happen. So when I talk about a will, I tell everybody it starts with the W, but so does the word wishes. In the will, you're telling a judge what you wish would happen, who you trust to manage your estate when you die, and how you wish your property will be distributed so they don't go back to that default statute and do it like the legislature told them to do it. It's your wishes, but a will does not pass property. So just because I have a will and I go to the bank and I say, I'm the heir, and they're going to say, where are your letters of administration? I can't give you what's in that bank account because it's just a will. Now, that's better than not having a will, but it's not going to transfer property when you die. Trust will transfer property when you die without probate. But guess what else will? Having a beneficiary on your account. Payable on death clause. Maybe you have your title for your car in your name, transfer on death too. When I die, that title passes. They can take it to the tag office, pay their fee, and transfer that title without a probate. So, go ahead. Do you have a question?
How do you get those provisions added, payable on death? What steps do you have to take to have that put on the different bank account and car and stuff like that?
That's a very good question. The question was, what do we do? How do we make payable on death? So there are some assets where you can utilize a payable on death clause, but it's not for everyone, okay? It's all statutorily provided. Your bank accounts can have beneficiaries. Insurance, right? You can have beneficiaries. 401ks, you have beneficiaries. All bank accounts have beneficiaries. Sometimes they'll call them payable on death. Sometimes they'll just call it beneficiary. You call up your bank. You got a checking account. You got a savings account. You got a CD there. If you do nothing else, do not die and leave that in your name only. Okay. If it's $50,000 or less, your family can do an affidavit, but everybody who is an heir has to sign that affidavit to transfer that property. And maybe they get along, and maybe they don't. okay? But if anything, put the beneficiary on there. Now, there's some limits, and let me explain what they are. Call up your bank, I want to add a beneficiary to my account, okay? If I die, I want to make sure it's going to go to somebody. So if I put 2 beneficiaries on there by law, they get 50-50. If you put 3, they all get a third. If you put 4, they all get a quarter. It's how the law is structured. So you can't say, I want 3 people on there, but I want one to take 50% and the other 2 to share the other half. So there's some limitations on payable on death clauses or beneficiaries. You can do a TOD, a transfer of death, on your car title. Okay? You just tell them at the tag office. That's the way you want that thing titled. You can also do a transfer on death deed for real estate. Our legislature got really smart about 5-6 years ago and gave us that. So that was a really blessing because real estate ties us up in probate a lot. So if you don't have anything else, you can do a transfer on death deed. So what do? You do a transfer on death deed and you go file it in your county records. It's a pretty simple process, not very expensive to do, but at least that property will transfer upon your death. A lot of people come to my office and they say, well, I just want to put my kids on my house. Why? When you put your kids on that property, you just gave them a gift. That's their property. It's your property too. Problem is it may not be their homestead. So now we get outside of some protections and exemptions you have. And what if they have child support issues? Or what if they hurt somebody in a car accident? And there's some creditors that need to come after them. Well, that's your home, but it's also property they now own. So a transfer on death is another way of doing those types of things. A transfer on death is revocable at any point in time. Last one on file wins. You move, it goes away. So there's some things that we can do outside of just the will or with the will, and making sure that we can do other things with your assets to still make sure you don't go to probate. Because in probate, people think it's really scary. I mean, sometimes it can get complicated if we can't get all the heirs in an agreement, but it's not always complicated. Is it expensive? Sure. I mean, nobody wants to pay that hourly fee. That's the reason we do all this planning in the first place, right? Make sure we get our property where we want it to go, make sure the kids are taken care of, make sure that I'm taken care of, make sure that I have the right people in place. We want to lower our tax burdens. We want to lower that other thing that everybody hates. Does anybody want to guess what it is? Attorney's fees. Yeah. We plan it right, we're only going to pay it once, right? Not for the estate plan and for the probate. Okay, so when you talk to somebody about estate planning, ask questions. Why do I need that? Why do you feel like I need that? A lot of people also don't want to disclose a lot about their assets. It's an uncomfortable conversation for some people. A lot of times the kids drag a parent to my office. And my question to them is, do you want them here? Because we have attorney-client privilege in our discussions. And if you don't want them there, I'm going to ask them to leave. It's not their property, it's your property. And so I want to know what you want. I don't want to know what your kids want. I appreciate their opinion in that matter. They may be taking care of you, but at the end of the day, I have to know what you want. What are you trying to do? Okay, because you're the client. So when you go and they start talking about it, we want to ask a lot of questions about why. So what would I normally see in an estate plan? We're gonna probably have a will. We might have a trust, and we may not have a trust. We're going to have powers of attorneys. In Oklahoma, we have 2 different powers. We have 3 actually, but we have 2 for finances. We have one that's a statutory power of attorney, and then we have one that we just refer to as a durable power of attorney. They're very similar in nature. They do almost the same thing, but they take care of all the financial aspects. When you give a power of attorney to somebody else, you're letting someone be your agent. Think of yourself now as an employer. With the power of attorney, you have gotten an employee, and they're going to act on your behalf. If you've got property and you've given them a pretty broad one, they can sell property. They can take out loans. They can sign for things. They can call your bank and ask questions. So a power of attorney can be very broad or very limited, but there are 2 different ones in Oklahoma. There's also one for medical. Okay, doctors like to have their own. They want to know what it is that you're wanting as far as your medical. Who's going to be able to access your medical records? Will they be able to make decisions about your long-term care? Will they be able to make decisions about whether or not you should or could have a surgery? Will they be able to sign those authorization forms? So there's a medical power of attorney out there too that you may have in an estate plan. You have an advanced healthcare directive. And our speaker before me, she spoke a little bit about that. Doctors want to know, while you have the ability to know, what do you want to happen on end-of-life situations? That advanced healthcare directive is just that. Do you remember the case out in Florida? I think her name was Marie Shriver. I probably get the last name, the pronunciation wrong. The lady that was in a coma, right? She was only being kept alive by machines, and she had a husband and she had parents, and she had been in that state for many, many years, and the husband had decided it was time to take her off the machines. It didn't appear in any way that she was going to recover from that situation, and her parents asked the court for an injunction to stop it, because they believed in their heart of hearts that their daughter would actually come back, and their husband said, no way, it defies medical logic, the doctors are in agreement. So what do the doctors do? They don't do a darn thing, right? They're going to have to let this thing play out in court because they have liability. Whose directions do I follow? Do I follow the husband's or do I follow her parents? It played out in court, and ultimately the husband was decided to have that authority in that situation to make the decisions on behalf of his wife. Out of that, though, we get the Advanced Healthcare Directive. There's 3 main questions on that document that are true end-of-life situations, and you get to respond to those, and then you get to add that but, what if language on there. And all of these are revocable, unless you have an irrevocable trust. All those other documents, they're revocable because your life changes. What happens today, you could have a whole different life in 5 years. And so they're revocable, they're amendable, and I encourage people to, it's not a one and done deal. You want to do the bulk of it, the work, but just do a checkup on it. You want to make sure that your estate plan stays in good health as you travel along through life. So out of those kind of that big, broad, huge overview that I gave you, does anybody have any questions? And I'm going to give you a caveat here. I can't answer sometimes your very personal questions because of client confidentiality. So if you get too deep into something, I may say something like, would you please contact me at my office? And I'll be happy to talk with you about that. Now the reason is I'm not avoiding you because I have no problem saying I don't know because I can't know everything. So I'm not trying to evade the question. I just want to make sure that you're also protected. But I am happy to answer generalized questions.
I had a lady call, and she has a will from her mother who died last month. Left a car and a house to her. But she has 5 siblings, and they want their share. And she said, do I have to go to probate? Because you said in an article, we said that you don't have to have an attorney to go to probate. And I said, well, you don't have to, but it could cost you a lot of money in the long run. So if there is a will, do they have to go to probate if everything was left to her?
In Oklahoma, our assets transfer in accordance with their title. So what do I mean by that? There's a lot of different title property. A house is a deed, that's a title. A car has a title. A boat has a title. Bank accounts are considered title property. Checking accounts are considered title property. All of those things transfer in accordance with their title. So if I'm sole owner, I'm the only one on it, whether it's a deed or a bank account, and I die, it goes to my estate. That has to go through probate. There are some exemptions to that, okay? So if Mama was the only one on the deed, but she gave it to the child in a will is wishes, it doesn't transfer property. So that will has to then be administered through the probate court. She gets letters, what we call letters testamentary. That now gives her approval to go down and to do the things that she's supposed to do in accordance with all of those probate laws. It's a process she now has to go through in order to get the property, make sure that we've advised all the heirs, they've got the proper notices, we know what all the assets are, we know what all the debts are, and then at the end of the day, the court gets to see the will, and it's like, yep, she's the right heir, and then there's an order at the end of the day, okay? It could take anywhere from 3 months, could take longer than that, it all depends on what's going on inside that family. The shortest period of time would probably be about 3 to 4 months. Then, she gets the property. Could that have been avoided if there was a transfer on death deed? That certainly could have been avoided.
But I told her she should look to find an attorney.
The court system is open to everybody, right? It's a public system and it's open to everybody. If you have the wherewithal to do it pro se, and that means to represent yourself, everyone has the right to represent themselves in court. I always tell people when they ask me about drafting documents, should I get an attorney? And my answer to you is only if you want it done right. Okay? Thank you for laughing. So, it's not a sense of arrogance. It's the jurisdiction or the judicial system is complicated, and we know that, right? And it seems like it gets more complicated by the day. To get through the probate process smoothly, then you need to have someone to be your guide so that they can tell you all the steps and make sure that you are doing the paperwork right. Can you do that yourself? Sure. Is it going to be very time consuming? Could you make mistakes? Yes, because the court has to treat you as an individual the same way they treat an attorney. You're going to be held to the same abilities when you walk in that door. So yes, your answer was absolutely spot on. Any other questions?
So if you have a will and you have, say, like 2 kids, they're listed as beneficiaries, and you basically say in the will, I want my estate to go half and half between my daughter and son, house, car, money, everything. It can't be just that simple?
No, it can be that simple in a will, but what happens if there's titled property? Now it's got to go through probate. Will the judge at the end of the day make the distributions or require the distributions that you've asked for in your will? Absolutely, but it's still going to have to go through probate.
So how would you avoid in that situation? I was just under the impression that if you had a will and it was drawn up by a lawyer, stipulating those things, then probate is out of the question. No.
The only way probate would be out of the question is we have a will as a cautionary provision that there was a titled asset out there that didn't get the right type of titling in order to make that distribution happen. So remember, the will can't transfer a property. So if it's only in your name and it's a titled piece of property, there's no one to give it to but your estate. Once you give it to the estate, once that distribution gets made to the estate, it can be divided through the will, but it all has to go through the probate process.
Okay, I didn't.
Yes. So now if you had a transfer on death deed out there, if you had the will, but you had a transfer on death deed that gave it to the children upon your death that's filed, it's going to happen. It's already out there. You've already done it. And by the effect of law, upon your death, that transfer happens. There's an affidavit that the beneficiaries filed in the county records, and it's that easy then.
Okay.
Okay. Oh, right here first. No, go back there. Go ahead.
Oh, yeah, great, for the dependencies question. So John presented a situation where the person dying wants to evenly distribute it to a son and daughter. So that statute you mentioned earlier, if on the car title and the house deed that he's added them as beneficiaries of titled property, if he adds son and daughter on the car title and son and daughter on the house title, does that statute automatically give it 50% to each of them?
Yes, because what you've done is you've transferred it by operation at law upon your death in ways that we're allowed to do. So if I had Carol, Rolke, T.O.D., Tyler, and Samantha, okay, those are the first names of my children. When I die, that car is going to vest into those 2 children equally. If I do a transfer on death deed, the same way. I can do rights of survivorship or just jointly. If I do just jointly, then they're both going to get a 50% ownership in my house. And the only thing they have to do is, if it's a deed, file the affidavit in the county, or if it is a title, they're going to go down to the tag office and file the proper affidavit of survivorship then, okay? So can you just have a will? Absolutely. And if you don't want your property being transferred by what the law says, in absence of the will, then you need to have at least the will to make those things happen. But will it have to go through probate depends on what type of property do you have? How is it titled? And what are we trying to accomplish at the end of the day? Okay.
If you have an only child who is the POA and the guardian, and the titled vehicle, as well as everything else, is going to the only child when the person dies, do you have to have a TOD to put that only child's name on the title of the car?
If you have it in your name and your kid's name, that child already has ownership. Okay, what I'm talking about is not giving them immediate ownership, but giving them ownership upon death. Okay, so if the child's name is you and child, already has it, you and or child already has a part ownership in it, right? So if it's or, then the child can sell that car anytime, even though it's your car. Same thing with a deed. That's why I discourage you from putting your children's name on the deed now, because you're giving ownership now. Upon death, when you say we want to give it to the only child, well, just because you're the only child, would you most likely be the heir in a probate process? Sure. But if the title isn't titled properly, then it's going to go through probate. Will it ultimately get to that person? Sure, but it's going to go through a process, an administrative process through the court to get that distribution made. So if it's already on title, remember we're going to go in accordance with our title. So if I have a bank account and it's me and spouse and I die, those bank accounts are considered rights of survivorship. I die. Upon my death, the spouse gets 100% because he's already on title. But if he's not on title and I die, what happens? I either got to go through probate or they look to see if there's a beneficiary. If there's a beneficiary, payable on death, transfer on death, it's going to go that way. If there's no beneficiary and there's no joint owner, it's got to go through probate. Okay? Trust is a little bit different though. But we can put all of our property into trust. We change our titles to the name of the trust. Everything gets transferred through the trust without a probate process. It's like a contract. It's like a business.
And that handles a lot of small things that we want to go to particular people besides the big real property and cars and things like that.
Absolutely. And so it lets us do a lot more stuff. And also it keeps our business private. Because when you file for probate, all of your assets, all of your heirs, their addresses, it's a public system and anybody can go and look at it. That's why we get a lot of elder fraud when someone dies. Because people are looking at that. There's bad people out there looking at those probate notices and, going to a widow's house or a widower's house and saying, well, your spouse contracted to have this driveway redone, say $1,000. Well, they're in the middle of burying their spouse. They don't know what's going on. They normally pay. Well, they just got fraud. Somebody just committed fraud upon that person. So if you do a trust, it is a private document. Your district doesn't get filed anywhere. And whenever you pass, your successor trustee steps into your shoes, and then they have the authority to do everything that you were doing when you were alive. And that includes signing deeds, making transfers, closing accounts, and anything that we provided for them in that document. So what's best for you depends on who you are, where you're at in life, what your assets look like, and what we're trying to accomplish at the end of the day. There's no one size fits all. But be educated and ask a lot of questions. Does anybody have any more questions?
And trusts can't be easily contested either, can they?
I like to use the no contest clause in both my wills and my trusts. So what's a no contest clause? A no contest clause says I have thought this through, I have competency. If you contest this, if you contest its validity, if you contest any of its distributions, you get $10. So a lot of people are going to, and the courts uphold that because it was my contract, it was my trust. So that's to keep the family from fighting. It was your property for your distributions to make, and that's the way they should go. So I like to use the no contest clause.
Can you find the transfer upon death kind of documents online?
Yes.
I mean, if you've already got a will established, but you don't have that aspect of it, would it be easy, just that easy to download something like that, print it off, go to your lawyer and have it signed? And
Well, your lawyer should be able to draft one if you have an estate planning lawyer. What I told you was a statutory provision in Oklahoma law. So remember, we're in Oklahoma, so everything that we talk about today is valid in Oklahoma. This is our Oklahoma law. So Oklahoma law provides for a transfer on death deed. So you would find a document within there, or the legislature would say, if you have a document out there, a deed that looks like this, or similar to this, then that's going to be a proper transfer on death deed. So you can locate one. I would be very leery of just getting online and saying transfer on death deed or going through a forms company because they're like the wheels or they're old statutes. You have to be very careful about the way that they're executed, who they're executed in from, and they're signed at the end. And so you have to be careful because you can't just fill stuff in all the time and have it be valid. So I'd steer clear of that, but Kenny, if we look for the Oklahoma statutes, and you'll find the language, absolutely. Call your county clerk's office, and they may be able to point you in the right direction.
Thank you.
You're very welcome. Well, I appreciate you letting me be here. I've given everyone one of my cards, so if you have any questions or want to visit with me at a later date, please feel free to do that.
Thank you.
Thank you so much for coming today. We thank God and law for letting you escape the office and come visit with us today.
Thank you for letting us know.
Thank you. I want to wrap up today with just, many of you may think that this was called the scariest things because it is the day before Halloween. But that's not actually the reason this is called the scariest things. 3 years ago, my father was in the hospital. My mother had passed in 2015, and we were a very close family. So we even drew closer to my dad. And he got ill very, very suddenly. He'd been very active. And he was in the hospital. And we got the news day after tomorrow that he had inoperable cancer, and he had 6 days to 6 weeks to live. On November the 7th, he passed away. He was discharged that morning out from the hospital. He got home about midday. Hospice came in then, gave us what they called a death kit of medicines. We signed a lot of paperwork, and they left. There was a lot of people in and out of the house. As things progressed, it was getting hard for people to be there. So at the end, it was my sister and myself and my dad. And it was the scariest thing. It was the hardest thing. But it's one of the things, other than the birth of my children, that I cherish the most. I was the one that took my father's pulse, and I was actually taking his pulse as I felt the last heartbeat go from his body. And that's such a tender, sweet moment. So all these things that we talked about today, they can be very scary, but you're not going to avoid death. It's not going to happen. So while you have your mental ability to choose how you want to die, use that. Don't be fearful of that. Educate yourself, prepare, talk to your family, talk to your chaplain, your church, and just work through those things that are hard. It'll provide a lot of comfort, and really hold dear to your family. Take care of each other. Take care of yourself. Caregiving's hard. Don't beat yourself up if you're not perfect. Nobody's perfect. But do your best every day and take care of yourselves. Thank y'all so much for coming today. I really appreciate y'all being here. Thank you.
Thank you.
Thank you.